Hello, my name is Michael McCarroll. I'm an immigration lawyer practicing in Denver, Colorado. I also assist clients throughout the United States with their various immigration needs. We do a lot of fiancé visas at my office, and today I want to guide you through how to complete the form I-134 Declaration of Financial Support as part of the fiancé visa process. The form was changed considerably in 2022 as it is now used in the Uniting for Ukraine program. And so the form's a little bit confusing and definitely different than it was before, and there's a lot of ground to cover here, so let's jump right in. If you take a look at the page for USCIS here, it can be filed online for the people who are using it as part of the Uniting for Ukraine program. However, you will not be submitting this online. This will be taken by the immigrant fiancé to the fiancé visa interview abroad. The edition date of the form is very important. You always want to verify that you're using the correct edition date, and that is going to be listed on the USCIS website. Currently, it's the April 25th, 2022 edition. If we look at the form itself, it does have an expiration date here in the top right. You can ignore that. That date does not matter at all. As long as you're getting your form from the website and it is the correct version, and the edition will be at the bottom here, then you're good to go. This form may be used beyond October 2022. It's up to USCIS what they're going to do with that. Again, the edition date is what you need to look at, not this date up here. All right, let's jump right in. So I am filing this form on behalf of another individual who is the beneficiary. That's going to be the correct answer for fiancé visa cases. Part 2, information about beneficiary. You're going to put the first, middle, and last name here, other names used, date of birth, gender, alien registration number, if any. To locate the A number for the immigrant fiancé, look at the I-129F approval notice at the top right of the page. This form, if you look at the instruction, requires either an NA, N-A, or none as the answer if the question is not applicable or the answer is none. So you have to complete the form, and you're not going to want to leave any spaces blank, essentially. The way the form is from the government website, it won't let you type in, N-A, for example. So you can go to my website, K1VisaNow.com, and you can download a hacked version of the form where it will allow you to put the dash, for example, into the Adobe PDF. Okay, so go to K1VisaNow.com, download that version, and then you won't have any trouble typing all of this in. So if there's no other names used, be N-A, you can put the date of birth, gender, place of birth, country of nationality. The country of nationality may be different than the country of birth, and so if that's the case, go ahead and type the different country of nationality there. The passport number that you're going to use is going to be for the passport the fiancé will be using when they go to the interview and obtain that fiancé visa. So it should be the newer passport, not an old passport that's about to expire. You'll type in the issue date, the issue country, the expiration date. And for marital status, please do not put single, never married if the fiancé has been married before. It looks like you don't know what you're talking about. If the fiancé visa was divorced and the divorce documents were put in the I-129F petition and you go and say single, never married, it either makes you look dishonest or like you don't even know the beneficiary. So either way, it's not good. So if the beneficiary's been married before, you're typically going to select divorced, widowed, or marriage annulled. The beneficiary's mailing address here. In care of name. Some people are confused about that. That simply means if somebody else receives the mail for the beneficiary, for example, the beneficiary's mother might receive the mail for the beneficiary at the mother's residence, in which case you would type in the mother's name and the in care of. But you can also leave in care of blank, and you definitely don't need to put N-A or none in the in care of field if it doesn't apply. Are the beneficiary's mailing and physical address the same? Maybe, maybe not. If the answer is no, then you need to provide the physical address. And the physical address is where the beneficiary essentially is domiciled. So where they sleep, where they, live. If they're on a short vacation for 2 weeks and staying in an Airbnb, you would not include that. But anything more substantial than that, probably. So it's going to be the domicile of the beneficiary where they basically intend to be living currently, not in the United States. You're not going to provide the petitioner's address there. The beneficiary's daytime phone number must be provided and the mobile phone number. They most likely are the same. That's fine. Reproduce the phone number in both spots. Do not leave a section of this form blank, please. Beneficiary's email address will go there. Okay, this is a little bit confusing. Beneficiary's anticipated length of stay. When does it start? Well, you don't know. You're guessing. I would guess 30 days after the interview. So when the fiancé visa interview is scheduled, let's say it's September 21st, 2022, just go ahead and plug in October 21st, 2022. It's anticipated, meaning it's guessed. It doesn't have to be accurate. And it really doesn't matter too much. So I would just guess the anticipated entry date will be approximately 30 days post fiancé visa interview. Now, sometimes clients may say, well, I have school, I have things to wrap up, I don't want to enter the United States so quickly. I really wouldn't worry much about that. That's not really the purpose of this form, and plans can always change. So an anticipated date of 30 days post interview I think is more than reasonable. And of course, there's no end date because the fiancé intends to enter the United States and marry the US citizen and live happily ever after here. So we're going to say no end date for that. Okay, beneficiary's financial information, beneficiary's income. Most of the time, this is going to be zero because when the fiancé comes to the United States, they'll be quitting a job. They won't be working. It's rare that somebody's going to have a remote position that's going to keep them on salary wherever they live in the world. And I guess in that particular situation, you may consider adding it here if it's easily verifiable. Otherwise, just go ahead and say zero for income because you're not trying to prove that the beneficiary is a hardworking person or ambitious or not a mooch or something like that in this form. That's not really the purpose of this form. The purpose of this form is to verify that the petitioner's income level is above a certain threshold. And because the beneficiary is most likely working abroad in most all cases, and they will be moving to the US and not have a job when they get here, you're probably going to put zero here. Again, there's going to be some fringe cases where that's not the situation, but most people are going to be putting zero. And then if the beneficiary has a child that's accompanying them, they will also list the child there and most likely also put zero. So self would be typed for the beneficiary here on the top line, zero as we discussed, and then maybe child will be included with all this information here and then zero over there. Does any of the beneficiary's income come from illegal means? No. So if you're checking yes, that some of this income came from illegal gambling, illegal drugs, something like that, you have problems, okay? You're going to need an attorney for sure. But most everybody normally is going to be selecting no because that's not the situation. So the amount that comes from illegal means is generally going to be no. Does any of the beneficiary's total income come from public benefits? Generally, this is going to be no, okay? We're already at a zero number, but moreover, most of the beneficiaries are going to be outside of the United States. So it's hard to think of a situation where this is going to be a yes answer. Again, this form is used for a variety of different reasons, not just for the fiancé visa, so it's a little bit confusing if you're looking at it just from the point of view of a fiancé. But this is most likely going to be no here. Scroll down to beneficiary's assets. We're not trying to overachieve here or show that the beneficiary is worth a lot of money or anything like that. Also, any assets that you're going to list here have to be appraised. So even if the beneficiary owns a home, unless you want to go out and get a new appraisal and have mortgage documents and all that kind of stuff, most likely you're not going to be including the home here. Same thing with the car. First of all, the instructions say the first car can't be included, only a second car. But again, are you going to get your car appraised? Is your car worth that much? who knows? Okay, cash, stocks, stuff like that can be listed if it's significant. I would say anything above 10,000 can be listed. It's super easy to verify, and so you can include evidence of that. But $5,000, something like that, it's not significant enough to even probably warrant listing here. If the income for this form for the petitioner is not sufficient, then trying to piece together all these tiny little assets and stuff like that is not the way to go. We always recommend just using a co-sponsor. It's just so much easier and so much more likely to succeed. So, if you need to get an appraisal of your home and stuff like that, it can be done in fringe cases where it's really needed. However, most always people either make enough income or can get a co-sponsor, so it's just not worth the hassle. Okay. Information about the individual agreeing to financially support the beneficiary named in Part 2. So this is the U.S. citizen petitioner. You'll be typing their name, other names used, if any, if not, NA, current mailing address. Is current mailing address the same as physical address? We discussed that. You may need to provide a physical address if different. Date of birth, state of birth, country of birth. A registration number. Okay, alien registration number. A lot of my clients, they're U.S. citizens. They say, look, I don't have an A number because I'm a U.S. citizen. And I tell them, well, you had an A number, you were naturalized, you're a naturalized U.S. citizen, so where'd that A number go, right? You still have it. It's still your A number. If you're a naturalized U.S. citizen, go ahead and provide your alien registration number there. Okay, otherwise put N/A. USCIS online account number, not required, but if you have one, go ahead and list it, otherwise NA. What is your relationship to the beneficiary? Fiancé, right? Okay, immigration status. What is your current immigration status? U.S. citizen, right? All fiancé visas are filed by initially the petitioner is a U.S. citizen. Employment information. Okay, so for the petitioner who is employed, then that's usually easy. If somebody's retired, that can be easy too, as long as we have 1099s or tax forms to prove that income. If the petitioner is self-employed, it does not receive 1099s or pay themselves with a W-2, for example, if they're an S-Corp owner. If they're just like a sole proprietor or they own an LLC or something like that, there's no tax forms like W-2 or 1099 to prove income, then even though the tax return might show that they make a certain amount of income, they might not be credited that income. And especially not on the 864, which is another form you have to file once the fiancé is in the United States. So I would recommend a joint sponsor in that case. Even if the petitioner has assets, let's say the petitioner has $100,000 in liquid assets, you can include that. Most likely would be fine for this stage of the process. However, because USCIS is so finicky with assets and they issue RFEs so frequently over assets, even my clients with assets, I recommend them to get a joint sponsor, right? And so if you're going to do that later on for the 864, you might as well add the same joint sponsor on for the I-134 at this stage. Even if you have the assets, it doesn't hurt to kind of provide that extra level of income there. It just will be so much easier for the immigration officer to make a quick decision on that. All right, so you type employed, unemployed, retired. Look, unemployed. If you made money last year, your W-2 shows like $100,000. Let's say you even have a job offer, you're about to jump into a job in a month, you're gonna make $100,000, but currently you're unemployed. Sorry, can't use your income. Okay, it's not gonna work. You're gonna need a joint sponsor. All right, so all of that will be typed in, employer's address, all the information here. Assets for the petitioner. Same kind of analysis goes for this. Any assets are going to require an appraisal unless they're liquid. So, most of the time you're not going to be listing a home or a car or stuff like that. And if you don't make enough money income-wise, you're going to want to get a joint sponsor. But you can definitely include, cash, stocks, anything that's easily valued and verified. And of course, the income is most likely not going to come from illegal means. If it does, you have serious issues you're going to need to discuss with an attorney. And does any of the income come from mean tested benefits? That's most likely going to be no. And if it's yes, again, get a joint sponsor. Okay. And excuse me here, make sure that there are two tables. This is the income table at the top here, where the income goes, and then the assets, which we already discussed, would go below there. Financial responsibility for other beneficiaries. If you read this question on this current version, it asks if you've previously submitted a form I-134 for another person. Okay? It's a very narrowly worded question. And so it does not include cases where you've previously been a joint sponsor for an H-64, or you sponsored somebody else before with a different form and they're a permanent resident now. So take the literal interpretation of this question and only answer yes if you've previously submitted a form I-134. Previously, for someone else. Not concurrently now with this case, but previously. So that's most likely going to be no there. Okay. Do you intend to provide specific contributions to the beneficiary? A lot of my clients want to say no here because they think, the beneficiary is educated, hardworking, definitely not a mooch, maybe more wealthy than the U.S. citizen. And so why would they say yes? I'll tell you why. Just because it's easier to say yes, and it just makes more sense. So you'll click yes, I intend, and then you'll type in something like this. I intend to provide room and board and anything else required by my fiancé, first as a fiancé and then as my spouse after their arrival in the United States. Something to that effect. That's how I've been typing in the I-134s for a long time, and it's worked just fine. And I think it makes a lot more sense than saying, no, I don't intend to contribute at all to the beneficiary named in Part 2. Right? Part 4 is not required for a fiancé visa case. Okay, so it's the beneficiary will not be signing this form or filling out their contact information in Part 4. Because if you read here, it says, if you are the beneficiary and filing form I-134 on your own behalf. Well, question number 1, we said no, this is not being filed on your own behalf. This is being filed by somebody else, the U.S. citizen. Okay, so this section will not be completed. You can just throw NAs throughout. And then the U.S. citizen will complete their contact information and certification and sign the form here at the end. The form must be printed and signed with ink. It can't be DocuSigned or electronically signed. You want to print, sign with black ink. Be sure to date as well. And then the original signed final draft of this form must be provided to the immigrant fiancé, mailed to them abroad if necessary, to bring to the interview, the fiancé visa interview abroad. Okay, so that's basically a step-by-step guide on how to complete the I-134. Of course, you're going to want to have an attorney review everything, and this is not legal advice, but it's a good step in the right direction, and I hope it was helpful. Thank you very much. Have a nice day.